Okay, folks, Ted Bisner here again. I wanted to go over the proposal for change sent to the Michigan Supreme Court here in September, on September 8th or 9th, 2016. It's now October 6th, 2016, and I've heard back now from the Michigan Supreme Court through their Office of Administrative Counsel. Basically, what I wanted to do was show you what we've done here and why. First thing I'd like to do is discuss the proposed change that we've sent to the Michigan Supreme Court. Here's the cover letter. Proponents are listed as Ted Bisner and Daniel Austin, the Michigan Justice League, name, address, phone number. Respondent is the Michigan Supreme Court. Page 1. These are the recipients of everybody that got this notice that was created on September 8, 2016 and mailed out via certified return receipt request mail. Responses came in from all of these folks over the course of the next couple weeks. And before I get into this, I'd like to switch over to the documentation that is put out by the Michigan Supreme Court that talks about how to initiate this proposal for change. This is a document created by the Michigan Supreme Court, processing of cases and administrative matters. It's got its index here. The first item is the disclaimer. Okay, one of the things that has us so screwed up here right now and pissed off is that the disclaimer by the Michigan Supreme Court is an admission that no attempt has been made to comprehensively analyze the court rules in Michigan. Okay, just take a second and wrap your mind around that. The people today of the state of Michigan are being forced into compliance with court rules that haven't been comprehensively analyzed by anybody. And these court rules are being put out by the Michigan Supreme Court, and we're all supposed to follow them like they're legislators? Okay, but anyways, in this same document, on about page 8, give me a second here. Okay, page 8, Supreme Court Administrative Matters. What's covered? The Supreme Court's administrative process, which is not a lawsuit, involves proposed amendments of rules and regulations within its jurisdiction. This includes the local Michigan court rules and these other 5 items. Initiation of the court's administrative process. Proposals for change. Proposals for rule or regulation change are initiated in a variety of ways. The court itself may decide that change is needed on the basis of issues presented in a given case. A proposal might also come from outside organizations. Organizations that initiate amendment proposals include these following 6 items. The first 5 of which are all State Bar of Michigan people. The State Court Administrative Office, the State Bar of Michigan, the Judicial Associations, Lawyer Associations, court-appointed committees, individual lawyers, and, of course, last but not least, we the people. The proponent of change should state the issue, describe the background regarding the suggested change, and provide rationale and authority for the change. It is advisable to present draft language of the rule change proposed for the court's consideration. A proponent may enlist the support of appropriate groups. The proponent of the rule change should send the request to the Office of Administrative Counsel at their P.O. Box 30052 in Lansing, Michigan. Acknowledgement of the proposal is what we basically got back here this week, and I'll show you a copy of that in a minute. The Supreme Court's Administrative Counsel is responsible for supervising and processing the administrative files. Once the court receives a proposal for change, of a rule or regulation, the court's administrative counsel sends an acknowledgement to the proponent. In this case, it would be Ted Bisner and Daniel Austin. And flipping back here to our proposal for change, again, it included this cover letter, proposed change, elimination of Michigan Court Rule 3.920H. And starting here on page 1, notice to agent is notice to agency. Notice to agency is notice to agent. Ted Bisner and Danny Austin are the proponents of this mandatory change correction and draw our support from the people of the state of Michigan and additional support from the state's unregulated militia. This same information was released publicly on social media last summer, and the only changes that took place were Supreme Court Justice Mary Kelly's resignation, and the raiding and looting of my family's home, and the theft and or destruction of all of my family's personal property located at that home. That included 3 laptop computers used to do this work. On September 17, 2015 in Blanchard, Michigan, where I was kidnapped and held for 8 days on excessive $200,000 bond for 4 misdemeanor charges in the state's retaliation of these same claims. So I came public with this information on Facebook. And within 2 weeks, Mary Kelly resigned, and then on September 17th, my house was raided. All my laptop computers were stolen. Actually, all my computers were stolen. Excuse me. And that was the response. It obviously wasn't an official response to me going public with the same information. Excuse me. Just getting over a cold here. But here we are now, using the Supreme Court's own process for initiating the proposal for change as proponents. And that's what we're doing here. Okay, MCR 3.920H. This court rule is completely unconstitutional and criminal, as it creates a direct harm and injury to the people by the conspired intentional deprivation of the people's unalienable due process rights secured by both the state and federal constitutions. And here I've quoted MCR, Michigan Court Rule 3.920H. Notice defects. Okay, first off, you have to know that notice defects are terminal to proceedings, completely terminal. You know, if I sue you and I don't send you notice, you've not been sued. Okay, no proceedings initiated against anybody without proper lawful notice exist. They're a fiction. They're not even there. They're not even worth talking about. And this is the way the state of Michigan and county prosecutors throughout Michigan are getting respondent parents in CPS cases into court without due process. It's because of this court rule right here. And that's why we're doing this. So, MCR 3.920H, notice defects. The appearance and participation of a party at a hearing is waiver by that party of defects in service. Bullshit. Bullshit. It's not even possible. It's not even possible, folks. This would have a specific reliance upon the notion that everybody is as smart as a lawyer walking into court. Everybody would know this and understand what notice defects are. Okay, and we don't, because we have better things to do. Soccer games, etc., etc. Okay, we're all busy. We don't know the Michigan court rules, nor do we need to. We're not obligated to be dictated to by the Michigan Supreme Court as if this were some sort of legislation. Okay, back to Danny and I's letter. This alleged Michigan court rule is and has been the recipe for disaster of many Michigan families, even though it's entirely void due to its unconstitutionality. And I should have put criminality on there too. Okay, going to page 2. County prosecutors like Isabella County Prosecutor Risa Scully throughout Michigan have come to rely preemptively upon this rule to intentionally deprive respondent parents of their due process rights by getting them into court without proper lawful notice and depriving them of their ability to seek and find appropriate competent legal counsel compounding this to include violations of the people's Sixth Amendment right to counsel of choice and the people's right to put up a proper defense in Michigan county courts. This is more than a 4th and 14th Amendment violation, folks. This is also a violation of your right to have appropriate counsel represent you in court or help you with your case. In addition to the unconstitutionality of this alleged Michigan court rule, this rule also constitutes the conspired deprivation of rights under color of law, and I've coined it color of government, and is a federal crime as defined in Title 18, Sections 241 and 242, and since these proceedings are initiated with the goal and intent to take Michigan children from their biological parents, this constitutes kidnapping, where the sentencing provisions of Title 18, Sections 241 and 242, could and should subject the creator and maintainers of this bullshit court rule to sentences of death. Okay, we have to understand here that this court rule is being used to get parents into court without proper lawful notice. They're not given any time to find proper legal counsel, and they're forced into court immediately. And this court rule is saying, that's okay. You've showed up now, so that's good enough. And that's total bullshit, folks. And this court rule is created by the Michigan Supreme Court. Okay, not checking the constitutionality and criminality of the court rules being imposed upon the people by Michigan Supreme Court and the Michigan County Courts and Michigan County prosecutors is massively and criminally negligent, as this particular court rule is being used to kidnap Michigan children and allows the state and counties of Michigan to profit from doing so through the federal Title IV program. There's motive. There's intent. In summary, the Michigan Supreme Court has created and does maintain the vehicle used to traffic Michigan children for profit to the state through Michigan Court Rule 3.920H. We have seen the intentional abuses of this criminally negligent court rule firsthand in the Daniel Austin case in Isabella County, Michigan, case number 14-99-NA. Daniel Austin's 3 children were taken by the state without a court order, kidnapped, and the petition to take her children was ultimately denied by the court, but her children were never given back to her. Daniel was called in on the telephone the same day her children were abducted without an order of the court and told that she had to appear in court that same day. At the courthouse, Daniel Austin had already been assigned a court-appointed lawyer by the name of Tony Moses without her knowledge, without her consent. Tony Moses was given the summons and petition by the woman Wendy Yost, who swore under penalty of perjury that she had personally served Daniel Austin as per the directions on the proof of service when she had not served Daniel Austin at all. Wendy Yost committed a 15-year felony perjury by claiming that Daniel Austin was properly served. Wendy Yost never served Daniel Austin as directed by the proof of service, which is SCAO Form JC21, and in accordance with MCR 3.9250B5, and only gave the summons and petition to Tony Moses, who had somehow been appointed by someone, somehow without any proceedings at all. William T. Urban, an Isabella County alleged so-called judge, as alleged judge, signed the summons the same day Daniel Austin was to appear in court, in violation of everything. William T. Urban signed the summons for Daniel Austin to appear in court on the same exact day, in willful violation of the orders in this document here. The proof of service required for child protective proceedings, this JC21, specifies that MCR 3.920B5 that Daniel Austin be personally served 7 days before child protective disposition review hearings. There's no way that a judge should sign anything to get anybody in court on the same day. There is no process there. There is no due process. Alleged Judge Mark Duthie, another terrorist judge in Isabella County, denied the petition to take Daniel Austin's 3 children, knowing that it had already been taken, and didn't do a damn thing to get them back to her. Okay, the petition given to this Tony Moses, as allegedly served on Daniel Austin by Wendy Yost, and never was, goes in front of Mark Duthie, and it's a petition to take Daniel Austin's children, and Mark Duthie denies it, knowing that her children are already in state custody, and doesn't do anything to get Daniel's children back to her. Okay, back to the letter. Because of MCO 3.920H and the fact that Daniel Austin could not speak on her own behalf because of Tony Moses, her appointed attorney, and because she had no time to seek counsel of her choice, and because Daniel Austin's forced representation advised her to admit to everything if she ever wanted to see her children again, extortion, she has now been away from her children now for over 2 years. Parental alienation, obstruction of family rights, etc., 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 etc. Liability up the yin-yang. Excuse me. Daniel Austin and a great many other people in the state of Michigan have been destroyed by this bullshit court rule. And the clowns running the courts and prosecutors' offices are relying on a rule created by this court to do this. Terrible and criminal stuff to the people of Michigan, and specifically Michigan parents and families. Notice defects are completely terminal, and because some ignorant county-appointed lawyer or attorney won't object to the obvious notice defects doesn't mean that these criminal constitutional violations become somehow acceptable and or permissible. The reason we can't find redress here, okay, is because of Constitution of Michigan 1963 self-incrimination, due process of law, fair treatment at investigations. No person shall be compelled in any criminal case to be a witness against himself, nor be deprived of life, liberty, property without due process of law. See, this works to benefit the Michigan Supreme Court, because I've just told them that one of their court rules are criminal. I've just told them that the court rule that's criminal is also unconstitutional, obviously. Now, the Michigan Supreme Court is going to rely on the Constitution here and completely deny us access to this petitioning process as proponents for change to get rid of unconstitutional and criminal court rules that are ruining Michigan families. The Michigan Supreme Court justices are relying on the Michigan Constitution to maintain their fucking criminality. Folks, this is utterly insane. Okay, several other constitutional quotes. You can see all this on my Facebook at facebook.com/ted.bisner. Continuing on, both the 5th Amendment and the 14th Amendment to the United States Constitution prohibit governmental deprivations of life, liberty, or property without due process of law. The Due Process Clause of the 14th Amendment serves 3 distinct functions in modern constitutional doctrine. First, it incorporates, against the state, specific protections defined in the Bill of Rights. Second, it contains a substantive component, sometimes referred to as substantive due process. Third, it is a guarantee of fair procedure, sometimes referred to as procedural due process. Case site here, Daniel v. Williams, 1986. Moving on, page 4. The fact that I'm having to have a constitutional discussion with this state's Supreme Court is overwhelmingly disturbing to me. In the disclaimer of the Supreme Court's publication titled Processing of Cases and Administrative Matters, this court claims and admits the following. No attempt has been made to comprehensively analyze the court rules. This is bullshit. This is criminal negligence. This is an attempt at deniability. Well, yeah, we created the court rules, but we don't really know what's in them. That's the deniability part. You can't create something and then say, well, you know what I mean. Who the hell do you think is supposed to check the constitutionality of your work, you stupid assholes? And I say this because the Michigan Supreme Court is willfully destroying Michigan families. They are assholes. I have never been this fucking pissed off in my 49 years. This specific deprivation of due process rights sanctioned by the Michigan Supreme Court and these court rules are responsible for destroying a huge number of Michigan families, and this must stop immediately. Additionally, this bullshit Michigan court rule seems to be intentionally disguised as it is buried deep in unrelated title description section subchapter 3.900 proceedings titled Proceedings Involving Juveniles. To keep the people from actually finding the information that's relevant to CPS cases, the Michigan Supreme Court has lumped it in with proceedings involving juvenile delinquents. This is very deceptive, and I believe this is deceiving on purpose. Refusal or failure to set this matter for immediate emergency hearing is further demonstration of this criminal negligence and the willful obstruction of justice. The fact that the state, through this bullshit, criminal, unconstitutional, and unjust court rule, has amassed massive liability to the people it has harmed cannot be the reason and is not accepted as the reason or excuse to ignore this. Notice the agency again, served by Daniel Austin and Ted Bisner as proponents, petitioners, claimants, and victims. On September 8th, 2016, year of our Lord. Okay, this was sent to the Michigan Supreme Court. And I want to show you real quick what we got back. Let me just find it real quick here. Here it is, right here. September 30th, a couple weeks later, we get this response back. Dear Mr. Bisner, thank you for your recent correspondence. Please be advised that the proper forum for challenging the constitutionality of court rules is through a case pertaining to a specific court rule. Future correspondence will be placed in the file but will not generate a response. Are you fucking kidding me? This is the response I get? The Michigan Supreme Court feels necessary to advise me? I didn't ask for their advice. And telling me what the proper forum is for challenging the criminality of bullshit created by the Michigan Supreme Court? That's insane. Anyways, this is more than stonewalling, folks. This is the intentional criminality of our state's highest court. Okay, everybody on the list got a copy of this. Okay, every branch of lawyer assholes in the state of Michigan got a copy of this. The prosecuting attorney's circle jerk of Michigan got a copy. Everybody here on this list, and then some. The Attorney General, the Michigan State Police, the Prosecuting Attorneys Association of Michigan, the Michigan Sheriff's Association, the Michigan Judicial Institute, the Michigan Department of Civil Rights. You know, the regional Supreme Court administrative offices, all of them, all 9 of them, got a copy of this. At great expense, money I didn't have. I spent over $200 mailing this stuff out. And the letter I got back proves that we no longer have a judiciary in the state of Michigan. We're out of time, folks. And here's our answer. I found a Michigan court rule that is criminal on its face, unconstitutional on its face. And I bring it up to these people that are supposed to be governing themselves. And they start offering me advice and talking to me about proper forums. Proper forums? Anyways, I'm going to start doing this a little bit more because I like putting the forms up, and I don't have to make sure my hair is combed when I'm shooting myself video. Another thing I want to point out here really quick is that this isn't even signed. I don't know who Amy Jacobs is, and apparently she signed for Ann Boomer. Not that I know who Ann Boomer is, other than she's administrative counsel to the Michigan Supreme Court. But this is not a signature. Okay, Ann Boomer should have signed this herself. So it's not even signed. And I'm getting this back now after this document was sent to everybody. Everybody on this list. Well, that's it for this video. More later. Please subscribe and support our efforts here if you can.